Welcome everybody to today's lecture for our Geriatric Resource Certificate Program. This is the fourth lecture in our series. Just as a reminder, we've set this up so that we're sort of progressing from healthy aging. We started with the Rose Center. We went through some geriatric assessments. We looked at social determinants of health. So today we're going to look at Medicare versus Medicaid. A lot of times, especially people in healthcare, they think, Medicare pays for everything if you're older, right? They don't even know, right, that what Medicaid is involved in. So, with especially in today's sort of environment, those are important distinctions. So originally our plan was to send people to different sites. We would have gone to the Rose Center. We would have gone to the area agency. So today we're traveling to the office of Kyla Williger, attorney, and she's going to tell us about these issues associated with Medicare and Medicaid. Go ahead, Kyla.
All right. Hello. Let's see here if I can. All right. All right. We'll just go there. And so, hi, I'm attorney Kyla Williger. And I am going to talk to you guys about elder law and estate planning, which is what my firm handles. So a little bit about me. I am a double graduate from The Ohio State University. I went there for law school and I went there for undergrad. I also am certified by the Ohio State Bar Association as a specialist in estate planning, trust, and probate law. I'm one of the founding partners of Williger Legal Group, where I work with my law partner and my mother, Marta. Marta is a certified elder law attorney. So we only practice in these 4 areas of law. There's nothing else that we handle. We don't do litigation, criminal law, any of that. All we do is we do estate planning, estate administration, guardianship, and elder law and long-term care Medicaid planning. So, launching right into it, Medicare versus Medicaid. Unfortunately, whoever names the programs likes to get as close as possible to confuse you between SSI and SSDI and Medicare and Medicaid. It can all get very confusing, and people will often swap the two interchangeably, and they're 2 very different programs. Medicare is an entitlement program. So as long as you have paid into the program and worked enough and paid the Medicare taxes, you are going to be covered by Medicare when you go to apply for it. Medicaid is a welfare program. So for Medicaid, you have to reach certain medical requirements and financial requirements. Mainly, you have to be spent down to less than $2,000 in assets. And also, there's actually, when you say Medicare and Medicaid, there's a large blanket of programs that this can cover. Today, just to keep it simple, I'm really only going to be talking about Medicare and Medicaid programs for people over the age of 65. Because there are some for people who are disabled, some for, pregnant mothers, etc., and different programs like that for people under 65. But the rules are different for those, and it can all get very confusing very quickly. So I'm just talking about people who are over the age of 65 today. So Medicare. Medicare is a federal health insurance program. So the states do not have any part really in administering it. It is going to be the same in every state you go to. Medicaid is a combination of a state program and a federal program. So if you get Medicaid in Ohio, the rules are going to be very different than if you get Medicaid in Florida. But for Medicare, it is across the board going to be uniform in every state. So you can get Medicare if you are 65 and older, or if you are any age and disabled or diagnosed with end-stage renal disease. Medicare was never intended to pay 100% of your healthcare costs. So there are supplemental programs that you can buy into. You may have other insurance that covers as well. But for the majority of Americans who are over the age of 65, Medicare is the program they're going to be signing on for. Medicare does not cover necessary services. And if you are outside of the USA, usually it will not cover services outside of that. If you are going to get medical equipment, prosthetics, or anything like that, it has to be through a contracted supplier. So you want to make sure that you're going in service for all of those things. With Medicare, enrollment's automatic if you get Social Security or retirement benefits prior to Medicare eligibility. But for most people, you have to apply for Medicare. And there's a certain window that you need to apply in. And if you don't apply during that window, you can actually get penalized later on when you go to apply for it. So there's a 7-month window for your initial enrollment period, and that is based off of your birth date. So on the month of your 65th birthday, you can apply to get Medicare, or you can apply anytime 3 months before or 3 months after. But if you miss that window, you are in trouble. If you are covered under your or your spouse's current employer group health plan, if they're continuing to work, you may be able to delay enrollment in Medicare Part B, but you do need to have coverage of some point. So there's a couple different parts of Medicare. There's Medicare A, there's Part A, Part B, Part C, and Part D, and they all cover different things. So Part A, this is the one that pretty much everybody has. This covers your hospital stay. So it covers all inpatient hospitalization, and for most people, as long as you've paid in for those 40 months or those 40 quarters over your working lifetime, your premium's probably going to be zero. If you didn't quite meet the the requirement for all the 40 quarters, then you may have a slightly higher premium for Part A. This is the copays and the skilled nursing copay. So when you're covered in the hospital under Part A, for staying in the hospital for day 1 through day 60 in the hospital, it's going to be $1,484 a day that Medicare will cover. And then after 60 days in the hospital, then it goes down to where they're only covering 371 days for day 61 through 90. And then after that, you get a lifetime reserve. For skilled nursing, this is if you were in the hospital and then you were discharged to a nursing home. They will pay only for the first 100 days in the nursing home, and that should be for rehab to get you back on your feet. So for the first 20 days that you're getting skilled nursing, that's going to be $0 that you have to pay. That's going to be $0. And then it's going to be $185.50 a day for days 21 through 100. Medicare Part B covers medical. So this covers all of your outpatient services, all of your doctors, your providers, your medical equipment, and all of that. This one has a premium. Usually the premium is about $148.50 for most people. Now, if you're in a higher income bracket, you may have to pay a higher premium. But for majority of people, your premium is going to be $148.50. And this changes pretty much yearly where it goes up a little. And then if you are a late enrollee, like I said, if you don't go in that first 7 months, you may incur a 10% penalty for each year of delay that you were not otherwise covered. There's an annual deductible for this that you have to reach of $203, and co-payments are generally 20% of Medicare approved amount. Then there's Part D. Notice I skipped Part C because it's kind of a different beast from Part A, B, and D. But I'm skipping Part C for now just to go to Part D. Part D covers drugs. And a lot of people don't sign up for this right off the bat because if you sign up, you just don't need that many drugs when you first sign up. And Part D does cost money to be on. So if you delay this, you're also going to have that penalty period that you would have had with Part B. So you might want to sign up for it right when you get on Medicare. because if not, you may be facing a penalty period later on that would stick with you for the entire time that you are on Medicare Part D. Medicare Part D is offered by private companies that contract with Medicare, and it is available two ways. It can either be bought as a standalone prescription drug plan, or it can be available through Medicare Advantage plans. The initial enrollment is the same as Part B, so you sign up at the same time, and then everybody with Medicare can get Part D, and a lot of people aren't really aware of that. They're really only aware that they could get Part A and B or C. And then average monthly premiums are usually about $32.75. And the annual deductible, it depends on the program. It can be anywhere from $0, but it shouldn't be over $435 for your drugs. So coverage periods. When you are on Part D, each year your coverage periods are going to restart themselves. And so you've got your first deductible period, which is you pay full price up to the point of your deductible. And like I said, it's usually either $0, so you're immediately out of this period, or you are going to pay up to $435. And once you pay $435, then everything else will kick in. So after that, you go into your initial coverage period. Once you meet that deductible, you're just going to pay a percentage. This usually varies by plan, so it can depend on what it is, but usually it's about 35% for your generic drugs, and then I think 45% for your name brand drugs. Then after you reach up the initial coverage period, then there's what's called a coverage gap, which is the donut hole. This used to be a much bigger deal. In 2020, the donut hole has actually kind of solved itself. But now while you're in the donut hole, you're going to pay 25% for your drugs. And then after you've gotten through the donut hole, you're going to reach the catastrophic coverage period. And at that point, you are going to pay either 5% of the cost, or $3.60 for generics, or $8.95 for brand name drugs. But it's going to be whichever's less, 5% or one of those numbers. And so you may not need Part D if you already have credible coverage for your drugs through something else. And it can be hard to choose which plan you want to go on because they all have different cost structures on how they're formulated. The important thing is that you have some form of coverage, because if you are a late enrollee, you may incur a 1% penalty for every month of delay that you did not sign up for Part D, which can add up pretty quickly. If you don't sign up for 2 years, then suddenly you've got 24% penalty, which will stick with you. So then there's Medicare Part C, and we're going to come back to that. So Medicare Part C is known as Medicare Advantage. It is available to those people who are enrolled in Part A and B and live within the county. And these are structured more like HMOs or PPOs, like your traditional payment for insurance plans. So they are considered an alternative to original Medicare. So you would pretty much either sign up for Medicare Part A and B, or you would sign up for Medicare Part C. You wouldn't necessarily have them all at the same time. And most plans include a Part D as part of these plans. Or you can get Medicare Part A, Part B, and Part D. So it's pretty much an either or with those. And then at that point, you're going to pay any of the premiums and costs, and these networks and copays can vary drastically by plan. So it's more like the open market where you can choose whatever plan you want under that. It's important to know Medicare is not enough. Medicare was never intended to pay 100% of the health costs. And Medicare doesn't cover anything outside of the USA. And most importantly, Medicare does not cover long-term care. So if you are 65 and you are looking at going into a nursing home or needing help coming into your home for long-term care sort of things, you're going to be either privately paying, which can be very expensive. The average cost for a nursing home right now is anywhere between $8,000 to $10,000 a month. So at that rate, most people can't afford to privately pay that rate for a very long time. It'll dig into your wallet very, very quickly. So with long-term care, Medicare will only cover those first 100 days, and that's if you're in rehab that we were talking about. So if you're going to a nursing home, you want to make sure that you were admitted to the hospital, because a lot of times if you go to the hospital, they're only going to have you under observation, which actually you are not inpatient. You would not qualify for the 100 days of Medicare at that point. You want to get fully admitted. So if you think you're going to need to go to a nursing home for whatever reason, you want to make sure that you get admitted for 3 days, because for those 3 days of being admitted, you can then get transferred to a nursing home and at least have the first 100 days covered under Medicare. Now with COVID, there's been a couple changes with that. Currently, they are waiving the 3 days requirement because they're trying to get people out of the hospital as quickly as possible, especially if they don't have COVID. If you fall and break a hip and you need nursing home rehab, they don't necessarily want to keep you where you're vulnerable in the hospital to COVID. They want to get you out and get you into the nursing home. So currently that is waived, but it's still important that you are admitted as an inpatient and you're not an outpatient for billing Medicare. There is a discharge requirement for Medicare, and they have to discharge you to a safe place. So they can't just kick you back out on the street if you won't be safe at home. They shouldn't be sending you home. They have to send you to a nursing home, or with nursing homes, if they also have to have a discharge plan if you're in there. So you have to go somewhere safe. Even if you're not paying your bill, they can't just kick you out on the street. Usually they will try to discharge you back to a hospital at that point. If you feel like you are being discharged too soon, you can appeal that, and they are required to pay for your care in the hospital until that appeal is settled. So they have to keep you there for free. And at that point, you can call there's a couple different programs that can help you with your appeal if you think that you or a loved one is being shipped out way too quickly. So as I was saying, Medicare is not enough. So you need to have another plan in place. Some people have long-term care insurance, but I'm going to be pretty honest, it's pretty rare. I don't see too many people with long-term care insurance. First of all, it is ridiculously expensive to have long-term care insurance. Secondly, they haven't really figured out how to work it yet. From an insurance standpoint. So they're using a lot of the same things that they would evaluate as though they were giving you life insurance. So for example, if you are a smoker with a history of, heart disease, they're probably not going to insure you, or they're going to require very high payments for your life insurance. Well, with long-term care, things like that'll take you out quickly. You don't use the long-term care. But if you are incredibly healthy and then you get Alzheimer's or Parkinson's or one of those things where you're just unable to care for yourself, but you're really healthy, so you're going to live for many, many years, that's when you need the long-term care insurance. So currently, they're kind of figuring out how to do it. And usually by the time people think about applying for long-term care insurance, they're too old to get it. And then also it can be, as I said, just so expensive that a lot of times people don't go forward with it. There's nothing I can even tell you about long-term care insurance on what the standard is, because the policies vary so widely. You can have a long elimination period where they're like, okay, you need to be in for a year privately paying before the long-term care insurance kicks in. There can be a daily rate that says, all right, we will only pay, $20 a day up to this point. There can be varying times in the length of time the policy will pay for total coverage. And some life insurances have, or long-term care insurances have death benefits. So even if you don't use it for long-term care, you get it one way or the other in the end. And so I'm going to move on to the 3 main rules of Medicaid at this point. If people have questions about Medicare, I can talk about it a little more, but basically it's a medical insurance program that is allowed to people over the age of 65, and it's going to cover those main things. But if you're 65 and you're looking to go into a nursing home, other than those first 100 days, it's not going to be that much help. So Medicaid is a welfare program. And there's 3 main rules that you have to remember with Medicaid. The first rule is you pay first. As long as you have the money to pay for your care, Medicaid is not stepping in and they are not paying for anything. They also, with Medicaid, they may have a different view of what you being able to pay for your care looks like. They will want you to drain retirement accounts. They will want you to, sell things. They're not going to make you hawk your wedding rings or anything like that. But until you are spent down to $2,000, they think that you have the means to pay for your care. The second rule of Medicaid is if you had the money and you gave it away, you should have used it to pay for your care, and they're going to penalize you. So gifts are a really big deal. When you come to me about long-term care planning, that's one of the first questions I'm going to ask, because gifts make things really complicated. Rule number 3, if you have anything left over when you die, Medicaid wants paid back. So there's recovery rules. It's called Medicaid recovery. And so if you happen to pass away and still have a large asset, the state's coming after it first. It's really hard to go on Medicaid after the age of 65 and still leave an inheritance for anyone. And then in order to qualify for Medicaid, you have to meet 4 main requirements. And the first requirement is residency. You have to be a resident of the state of Ohio. Medicaid is a state-by-state program, so you can't get Medicaid in 2 states at once. You can't be living in Florida and getting Ohio Medicaid. You have to prove residency. This isn't too hard. If you've lived there a month and you declare that you have a desire to be a resident, you are a resident. And as long as you're not getting it from 2 states at once, they're okay with that. The second is you have to have a level of care needed. You need to need that medical care. Most times by the time people are looking for Medicaid, there's really not a question. This isn't a particularly high bar to jump over. Most people over the age of 65 at the point that they're looking to get Medicaid need Medicaid at least at a medical level. So the main things that I'm looking at when you come to see me as an elder law attorney is I'm looking at your income eligibility and I'm looking at your assets eligibility. It's really easy though now, this used to be different, but now if you come to me and you are an SSI recipient, you automatically are eligible for Medicaid. So they should be able to plug you in to the system and you automatically get it without having to jump through quite as many hoops. So for the financial requirements, the first thing I'm going to do when you come in to see me is I am going to break down everything you own can be broken down into one of these categories. Everything you own is either income, it is an exempt asset, it is a countable asset, it is sometimes an unavailable asset, it is a debt, or it is a gift. And so I want to figure out everything you have ever had in your life can be classified as one of those things. For income, you can be ineligible for Medicaid if your income is too high. This didn't used to be the case because we had a different organization of our rules. Because of the way the law has changed since 2016, you can now be too high for Medicaid income-wise. So this number goes up all the time. But currently in 2020, you can't earn more than $2,349 per month for the one person. That's just for the person who's applying for Medicaid. Your spouse's income doesn't count for that. So if I were trying to get on Medicaid and my husband had $5,000 coming in a month and I only had 1,000, income wise, it wouldn't be a problem. I'd be under that level. But if we reversed it and he was trying to apply for Medicaid with $5,000 in income and I had $1,000, he wouldn't qualify. Now, the courts do require there's a way to fix that. I absolutely hate this because it's a lot of red tape for absolutely everybody involved. And it just the only reason these exist is to screw you up so you do not qualify for Medicaid. But they are called QITs, Qualified Income Trusts. They're also commonly referred to as Miller Trusts. They say that Miller Trust is based off of the case that decided that this had to be law, that it was Miller versus the state of Illinois, I think. And the attorney joke is that it's because these things will make you want to drink a lot of beer because they are really annoying to set up. But essentially, the money comes into your main account, your income goes into your bank account, you move it over into the qualified income trust, and then that money comes right back out again to pay your medical patient liability and all of your expenses. It's very, very frustrating because it's really only there to screw you up. And it will, unless you go see an attorney for it. If income is in the account for over a month, it is no longer counted as income at that point. It is considered an asset. So it's really important that you get your money in and out within the same month, which is usually pretty easy to do if you stay on top of things. So then we get into exempt assets. Exempt assets are the things that you are allowed to have that Medicaid is not going to take from you until you pass away. And so for that, that's your family home. You are allowed your one residence. You are allowed all of your personal property. They're not coming after your rings. They're not coming after, your books or your television. Any personal property, they're not too worried about. There is a saying, pigs get fed, hogs get slaughtered. So if you suddenly go out and buy like 10 Rolex watches, that will probably be a red flag for Medicaid. They will not like that. But they're not going to judge you on the things you own, how nice they are. They're not going to come in and be like, nope, 5,000 is too expensive for a couch. You should get one for 200. They're not doing that sort of thing to you. The other thing you're allowed to have is a car, a very small life insurance policy. Usually we don't even see that in place for the exempt assets because most life insurance policies are countable, and you are allowed prepaid funeral and burial spaces for your entire family. There's something called a pooled trust, which is also an exempt asset that is available for people who are disabled. I think they're almost too good to be true. So for people over the age of 65, currently they are allowed in Ohio. However, there's a federal ruling that says they aren't allowed for people over the age of 65, but Ohio law trumps right now. In the future, that may change. And then there's this strange change that I will get to about retirement accounts that's being updated in 2020 as being exempt assets. This is very, very new and nobody knows what's going on with it yet, but it's interesting to think about. So for the family home, your home is exempt. It is safe. Nobody's looking at it. The home, if you leave the home and you go into a nursing home and you don't have a spouse at home, you don't have a dependent child at home or anybody living in the home, it can be expensive to keep a house going while you're in a nursing home. So if you don't have an intent to return home, they're going to make you want to sell the house, and you're going to want to sell the house at that point because it's going to be a drain and you won't have the money to keep it going. As long as you have an intent to return home, though, they can't take the house from you or force you to sell it. The house should have an equity of less than $585,000. If it is worth more than that, if you have $1 million home, then part of that will be a countable asset, but the $585,000 is exempt, and that is protected. If you have a dependent relative or a spouse in the home, they're not going to kick them out and make them homeless over that. You can file over that. And there used to be a rule that you could sell the house for 90% of the fair market value in Ohio and have it still be okay. So I could, for example, sell my house to a child, and if my house was worth $100,000, I could sell it to them for $90,000, and then they could do whatever they want with the house. They could keep it or sell it and net that extra 10 grand. They got rid of that rule, but they didn't replace it with anything. So we're not really sure what that means for houses. There hasn't been enough litigation for me to give clients a face value talk on that. Instead, we're just kind of like, well, sell it for 100% if you want to be safe. If you want to be risky, you could sell it to your child for 2/3 the fair market value. And at that point, there's a federal law that you have to back you up, but Medicaid may come after you for that. They may not like that. And then there's something that's called a caretaker child exemption, which is if you are a person who is living in your home and your child moves into the house with you and they take care of you for at least 2.5 years, if your doctor writes a note that says, if not for this child living with the parent for 2.5 years, that parent would have needed Medicaid 2.5 years ago, you can transfer the entire house to the child at that point without a penalty. It does have to be a child. You can't have a niece or a grandchild or anyone do that. B, they have to actually move into the home. They can't just be coming over a lot. And also, it needs to be for your benefit, not so much for the kid. If you have a child who's just been mooching off you for years, and they're not providing that help that would keep you out, it's not going to work. Other than those exempt assets that I just talked about, you are only allowed to keep $2,000 in your name. And that's it. And at that point, if your assets are over $2,000, other than those exemptions that I talked about, you're not going to qualify for Medicaid. They're going to reject you. So $2,000 is low. It hasn't changed in a while. It used to be $1,500 was all you were allowed to keep. I think about 4 years ago, they updated that to $2,000, but it's not looking like that's going to go up anytime soon. So 2,000 is the magic number. Countable assets is everything that's not what I named before. So anything you've got, CDs, savings bonds. I'm going to get back to the retirement accounts because those get complicated, but in general, they are countable. And then real estate, other than your primary residence, is countable. If you have 2 cars, the second car is countable. So all of this needs to be worth less than $2,000. You have a slight argument for unavailable assets. If you have like a house that you're trying to sell, but it just can't be sold yet, then it could be argued that it's unavailable. This is getting harder and harder to pass by the Medicaid boards. Debts, Medicaid's not really looking at your debt. They don't care if you have, if you have $100,000 in debt and you have $50,000 in assets, you can't make the argument that you have less than $2,000 because your debt is so high. They're not looking at debt. You would have to take the assets and actually spend it down on the debt to actually get below that $2,000. Other than that, Medicaid really doesn't care if you have debt or not, but it is a really easy, clean way to spend down to $2,000 is by paying off your debt. It's important to know you can only pay for the debt of you or your spouse. So if your child has, $100,000 in student loans, you can't pay that off for them. That would be considered a gift. So the easiest plan if you're trying to get on Medicaid is to do what's called a straight spend down. And that is where you just spend money. You spend it on yourself. You spend it on your nursing home care. You spend it on, shirts, things that won't be paid for otherwise. You can get a new television, a new rocking chair. The biggest thing to note is pigs get fed, hogs get slaughtered, like I said. So I once had a client who they had a power of attorney who was working for them. The client themselves was pretty advanced Alzheimer's in a locked unit. And so mom was pretty advanced in a locked unit, and daughter was trying to spend down money, and daughter bought 10 GPS units, one for each grandchild. And Medicaid was like, no, that doesn't work. You know, that's clearly a gift. And she's like, no, it's for mom's benefit, so the grandchildren can come and see her. And they don't like that. But if you buy them a computer, an iPod, a phone, anything like that, it needs to be in the nursing home with them, where it may get stolen, but it needs to be theirs. You can't be like, oh, we bought mom a big screen TV. She's in a locked unit. The TV's going to stay at my house for safekeeping. That's no good. At that point, it's a gift. But the presumption is it's a gift. So you want to keep really good records of everything you've spent when you go to apply for Medicaid. And you also, when you're spending the money, try to put the money where it'll do the most good. Prepay your funerals, pay down debts, buy anything that you may need in the future. Making gifts makes it a really complicated plan. So if somebody's going to make a gift, they 100% need to go see an attorney to make sure that they don't get penalized and not qualify for Medicaid because of that gift. If you are married, there are spousal protections in place. The ill spouse who is applying for Medicaid has to be spent down to $2,000 or less. However, the healthy spouse can keep some money, not a lot of money, but some money. So they're trying to make the ill spouse poor by getting them below $2,000 while not impoverishing the healthy spouse who's out in the community. And once again, Medicaid may have different views on what rich is, what poor is, compared to what your personal views are. So when you are married and you're applying for Medicaid for one spouse, you're looking at a snapshot date. And what a snapshot date is it is the day that they are looking at all of your assets, cutting it in half, and then allowing you to spend down for the one spouse. So the snapshot date is established in two ways. And when a client comes to see me, sometimes the snapshot date has already been established without them really realizing it. So it is established either when you first apply for Medicaid, you can force a snapshot date. You can apply for Medicaid and get rejected, and that'll establish your snapshot date. So occasionally we will apply for Medicaid, even if we know we have over $2,000 in assets, just to get that snapshot date established. The other way it can be established is if one of the spouses who's going to be institutionalized enters a hospital or a long-term care facility and stays for at least 30 days. Then the first day of that is considered the snapshot date. And on that date, they're just going to take a picture and split it in half. The community spouse gets to keep their half. The healthy spouse or the ill spouse has to spend theirs down to $2,000 or less. And there's a couple different ways that we can do this. But there are limitations on that to protect. When I say spend down the assets, the house, the car, the prepaid funeral are not counted in that asset that you only get to keep half. So you get to keep a house, you get to keep a car, you get to keep prepaid funerals, plus half of everything else. There is limitations on the income and the asset allowance. So the spouse may be able to keep some of their spouse's income after the ill spouse goes on Medicaid, which can help a lot, especially if you've got, the spouse at home earning less than the person who's going into the facility. And then these numbers are just based off of that. So they've got a minimum and a maximum. These go up every year. The community spouse will not have to pay their income to help the spouse when they are on Medicaid. They only have to pay the ill spouses, but they may be able to keep some of that. For assets, you are allowed to keep either $25,000 roughly, and that number changes all the time, or 128. So if, for example, I had $500,000 in assets, when we split it in half, I don't get to keep $250 as the healthy spouse. I only get to keep $128,640, and then I have to spend down the extra 300 some, you know, to get down to that 2,000 for the other spouse. So the main goal in planning for this is that you're going to try to get the most assets possible on the snapshot date so that you have the biggest number possible for how much you get to keep. And then you're going to split the assets and you're going to spend the institutionalized spouse's share on debts, pay for improvements to the home or the car or things that are going to help that community spouse stay there longer. So for example, a lot of my little old ladies feel pretty terrible because their husband is going into a nursing home and they're being told to go out there and buy the kitchen of their dreams that they always wanted, just to spend money down or to buy a brand new car and to do those things, because those are the things that are going to protect the assets best, because you got to spend it down. Otherwise, you're going to be paying $8,000 to $10,000 a month on nursing home care. Still make no gifts, because that'll complicate everything real quickly. If you do make a gift, or you want to make a gift, or God forbid you already made a gift and you can't get that money back, gifts are not illegal, but they are considered improper. So there's a 5-year look back period for any gifts that were made. So when you go to apply for Medicaid, that's the question they're going to ask. They're going to ask, great, you've got less than $2,000 in your name, your income is low enough, you definitely have a medical need, you are a resident of the state of Ohio, you qualify for Medicaid. By the way, have you made any gifts in the last 5 years? And that's where you got to come forward and complicate things. If you are before the 5 years, it is not an issue. Bill Gates could move to the state of Ohio, give away his entire fortune, wait 5 years, and then get Medicaid here. That is a possibility. But if it's in that 5 years, they're going to penalize you based on how much you gave away. So at that point, you're going to be put on restricted Medicaid for a period of time known as the penalty period. I cannot tell you how long the penalty period is until I know how much you gave away. And they change that number every year. It goes up a little bit, but currently for every $6,905 that you give away, that is 1 month that Medicaid will not otherwise pay for your care. So until that time, you have to find a way to pay for your care otherwise. And that can be through an annuity, a pooled trust, maybe retirement accounts. If you've all zoned out, I would like you to zone now. So to make gifts for Medicaid, you need a couple things, and this is where you can plan ahead. You need someone with legal authority to make the gift. You need either the individual has to have the capacity to make the gift themselves, or they need a power of attorney, sometimes a guardian. You need someone to receive the gift. The spouse receiving the gift, it's still going to be counted in the overall. So gifting to a spouse doesn't work very well. But you may want to transfer the house over. If you have children you trust, or better yet, if you have an irrevocable trust set up, you can gift to the irrevocable trust. You also need something to gift. Sometimes the parents come in and they want to make a gift and they have no money. So it's just not possible. And it works best if you've got liquid assets also, so you can cover that penalty period. And then if you pass away after all of this and you still have assets remaining, Medicaid wants paid back. They will put a lien on the house. They will not kick your spouse out while that spouse is living in the home, but children or anybody else they may come after. Sometimes you can bargain with the officer in a private agreement. There's not with Medicaid the same sense of, well, we've always done it this way. You know, if you go to a court hearing normally with law, there's going to be, well, how have we judged this case in the past? And then you're arguing over, well, this case came here. How are my facts the same? How are they different? To try to get to an outcome. For Medicaid, it really doesn't matter. You can go in and the officer can be like, well, I made this decision before lunch that we're not coming after this asset. And then they have a really bad lunch, they come back with a stomach ache, and suddenly it's like, well, you're screwed. Same facts, and we're gonna come after you for that. So do we have questions on this before I get to 2020 updates?
There aren't any questions in the chat.
No questions in the chat so far. All right. So 2020 updates for Medicare. First of all, they closed the donut hole. This used to be a really big issue because before you reached your catastrophic coverage and after you got through your initial coverage period, there was this hole of about $2,000 or so in there where you were charged pretty much almost full price for your drugs and they weren't covering anything. So you would have an affordable price during the initial coverage and then it would drop to 5% of the coverage after you got to the catastrophic area, but that donut hole in between, they weren't covering. They've now put it at 25%. So for a lot of people, that's a lot better and they can handle 25% a lot more than they could before. Then there's the Medigap. It's not that big of an issue. So for Medicare supplements, it's basically saying that they didn't allow new enrollees to sign up for your supplemental insurance when you were doing B&D. So you ended up paying more at that point. I think they're fixing that this year. Big change, they've issued new Medicare cards. So it used to be that your Medicare card had your social security number on it, which was a problem because it was leading to a lot of fraud issues. Now for security reasons, your Medicare card will now have its own individual number that is not your social security number. COVID has changed a couple of things. First of all, there's COVID coverage under Medicare now where they're going to cover your testing, they're going to cover your hospitalization, your vaccine, and all of that. And they'll do telehealth now, which before they weren't necessarily doing the telehealth as well. And then, like I said before, with the COVID, they've currently made that change so that they are not, going to require that 3 days in the hospital before you go to the nursing home. They're trying to get you in and out as quick as possible. And then in 2021, there's going to decide new income brackets for Medicare, which can affect premium costs. For Medicaid changes, the numbers change every year. They're always really weird numbers. I have trouble remembering numbers in general, so I usually have a cheat sheet of it, and they don't make it easy. They're not all the easy, clean 2,000, which is really easy. It's like the $6,905 now and all of that, which is ridiculous to pay attention to. But if you are even a dollar or a cent over, they will penalize you for those things. The biggest change is there were some Secure Act changes, which changes the way that retirement accounts go after you pass away. That doesn't affect the Medicare Medicaid scene so much. It more affects the estate planning side of things. And then there's this weird thing that the Ohio Department of Medicaid has done. And so they came in and they said, well, we mean this as a clarification. We've meant this the whole way through. We always meant it. This is not a change. And all the elder law attorneys and people are looking at them like, no, this is a massive change that you're instituting. And that is the treatment of retirement accounts. So it used to be the rule with Medicaid that everyone understood was basically for any asset other than your home or your car, if you could go to them and say, give me money to pay for my care, that was a countable asset. And as it didn't matter with an IRA if you were going to get taxed or penalized, if you could ask for the money, you had to ask for the money to pay for your care. So with that, they've now changed that rule supposedly, where the top is now saying, okay, if you have a retirement account that is in payout status with an RMD or something like that, then that account is not countable as an asset. So you could qualify for Medicaid with less than $2,000 in your bank account and a $500,000 IRA just sitting there, which raises a lot of questions otherwise. And so then they're saying payout status would be the income. So that could push you up to where you need a qualified income trust a lot more, which I don't like. And also, what is payout status? Because they don't really have that defined. We know that required mandatory distributions automatically count as payout status, but some things like Roth IRAs don't have a required mandatory distribution. So at what point is it considered payout? If I simply go in for 2 months and say, hey, give me $500 this month, give me $500 next month, does that count as a payout status? And since it's the Ohio Department of Medicaid that has made this ruling, but most of the Medicaid applications that you handle will be handled with a social worker at a community level, county by county. We're not seeing this applied. So if you walk in with a $500,000 IRA, they're going to laugh you out of the office and say that you don't qualify for Medicaid, which then I think we're going to see a lot of fights on. The other thing with that is it might be less of a spend down, which could get people on Medicaid quicker, which would be good for them. But it also could require more QITs because it's going to make your income go up. And then the question is even though it could be exempt, you may want to cash it in anyways. And if you want to make a gift or try to inflate your assets for a community spouse, it may make more sense to cash it in and not do it that way. And then the other question is once you pass away, what happens? Where does that money go? So most retirement accounts are going to pass outside of probate, and most of them pass by beneficiary. Recently, Ohio Medicaid recovery has gotten better about going after assets that pass outside of probate. For example, with a transfer on death affidavit for a house, you now have to mark whether you got Medicaid or not, and they'll put liens on your house so that you can't transfer the house out of the dead person's name without paying back Medicaid for the care that was given. And how are they going to enforce this with retirement accounts? Are they going to go to, Morgan Stanley and all of these places and require them to ask and alert them if somebody was on Medicaid? Are they going to make that mandatory reporting? Will you need to prove that you've changed your beneficiary to the state of Ohio when you apply for Medicaid? If this passes to heirs, is Medicaid going to attempt to collect on beneficiaries? There's just so many questions that the verification raises that I don't think the Ohio Department of Medicaid necessarily thought through all the way, because they don't have answers for this, which unfortunately means that I have far less certainty when clients come to me. They want to know what's going to happen. That's why you go to see a lawyer. You want to know all the answers. And a lot of it is like, I don't know, there hasn't been enough litigation to decide yet. And then there's also a question of, if you are drawing on a retirement account, are you required to take the maximum payment to pay that down and not try to save it for your spouse or anything along those lines? So everybody I can see is muted right now. I don't know if we have any questions that I can answer. If we don't have questions that I can answer, I have a couple hypotheticals that kind of show what I do. So nobody's jumping up to ask any questions.
I have a question.
All right.
Is there a 5-year look back on houses too? So like if you transfer a house out of a person's name to another person, like a quick claim, because you're trying to spend down their assets, is there a look back period, or it doesn't matter?
No, 100% matters. That's like one of the biggest things with a house or a car that they will catch you on for making a gift, because there's such a good record of a quitclaim deed being transferred in the last 5 years. They'll be able to look that up real quick. So yeah, if you are a parent and you transfer your house out of your name to anybody else, they're going to want to see the HUD statement and how much was paid for it. If something wasn't paid, if it was just transferred, that's considered a gift. So you will be they will be penalized for the cost of the house. So if your house is worth, you know, $69,000, that's going to be 10 months that they won't pay for your care. And if the house is worth more than that, the penalty period will be longer. There are a couple exceptions on who you can transfer the house to. You can, if you transfer the house to a caretaker child, which was that exception I talked about where the child moves in to care for you for 2.5 years, that's exempt. You just need paperwork to prove that that was the situation. You can also transfer a house to a disabled child. If you have any disabled children, there's pretty much an unlimited transfer allowed to them. So if you have a disabled child, you can take everything you own and transfer it to that child. You're just looking at whether or not that would affect the child's benefits if they are on government benefits, because it might. But yeah, transferring a house definitely counts in the 5-year look back period. So I'm going to go through a couple hypotheticals here. So
you have another question in the chat.
Yeah, great.
So how does it work for patients who live in more than one state for part of the year? Can people have Medicaid in more than one state?
So you need to choose which state is your residence. And so you can switch to getting Medicaid back and forth, but switching between programs is actually somewhat hard. So whichever one is your residence, you only get one residence, which would be essentially where you vote, is a really good sign of where your residence is. So the same way that you can't really switch, you know, if you live in Ohio and Florida, you don't get to vote twice. You have to choose which one your residence is. That's the one that's going to provide Medicaid. But like if you take a trip or you're away less than, you know, half the year, you know, that you can still get Ohio Medicaid while living in Florida. It's just going to be a little complicated and you'll have to deal with the residency issue. Any other questions?
Don't think so.
All right. So if I have a client, Clara, who comes to see me, it's always important in elder law that you know, in any form of law actually, that you know who your client is, because we're working with a lot of families and you want to know whose interests you're representing, because sometimes people can go, you know, their interests can be different from each other. So when we do elder law, we always represent the individual. We don't represent the kids in that. We may talk to the children as a power of attorney. And this is one of those areas where it's very important that in your pre-planning, and I mean this for everyone of any age, that you have powers of attorney in place. I think powers of attorney are even more important than a will, because I'm sure that most of you are in the healthcare field. You know about medical powers of attorney and how you can't talk to anybody who doesn't have a medical power of attorney in place. You really need not only a medical power of attorney, but a financial power of attorney, because if you don't have the financial power of attorney, you are looking at going to court to get a guardianship established. So any age, like I've had one since I was 18. I had a client who came in the other day, her 31-year-old child passed away unexpectedly. He didn't have an estate. He was living at home with his mother, and she wanted to see his medical records. And the release for medical records required that she be either a power of attorney or an executor of an estate. And he didn't have an estate set up. So we were looking at either opening an entire probate estate just to get medical records, or, you know, and that was the only option because she wasn't the power of attorney and she didn't understand, because she was his mother, how she couldn't get these for her deceased child. But powers of attorney can be really important in that area. And when we're talking about Medicaid planning, a power of attorney for finance is even more important, because otherwise full financial guardianship is needed, which can take months and be very expensive. So Clara comes to see me. She is an 81-year-old widow woman with no children. We would look at her health-wise. She's had a few falls recently. She has bipolar and dementia. She's going to need full-time care. So we look at her income. Her Social Security is $2,000 a month, and she has a pension of $255 a month coming in, and she has a required mandatory distribution from her IRA that is broken down to $166 a month. So her total that she's receiving a month is $2,421. So her assets, she really doesn't have that many assets, no house, no car. She has a checking account with $27,000 in it. And then she has an IRA with $100,000 in it, which gives her a required mandatory distribution of a total of $2,000 a year. Up until this point, she's been living in an independent living facility. She has no debt, and her sister has a power of attorney, and her sister also has the ability to set up a trust for Clara that's listed in the power of attorney, because a power of attorney can only do what's listed in it. So if you don't give a gifting power, if you don't give the ability to set up a trust, your power of attorney can't do it. So we've got two options for what we can do to Clara to qualify her for Medicaid. The new rules supposedly say an IRA is excluded. So the only thing she needs to spend down is $25,000 to get below that $2,000. So she can do a couple things to do that. She can prepay her funeral for $10,000. She can pay legal fees for $8,000 and buy anything that she may need for $7,000. Because her income is high with the RMD, we're going to need to set up a qualified income trust to receive the extra income from her IRA. So we'll need to get the qualified income trust set up before she qualifies for Medicaid, or else she will not qualify on an income basis. So that's one way we could do it. There's another way we could do it, and it's an option. Both of them have pros and cons, and we haven't worked out which one is necessarily the best. The other option is she could cash in her IRA before she applies for Medicaid. If she does it after she's applied for Medicaid, it really screws everything up. So that's not an option. But if before she applies for Medicaid, she cashes in her IRA, she could withhold for taxes because there's going to be a big tax hit. So we'll say $25,000 goes straight off the bat to the IRS. But that gives her $75,000 in her account. Now we have to spend down $100,000 because remember, she still got that 25 from her bank account. So at this point, we could prepay her funeral, which would be $10,000. Pay legal fees, $12,000. They're going to be a little higher because we're going to be doing some more complicated planning. And then buy anything Clara needs. She may only need $3,000 worth of stuff. And then we can do what's called a pooled trust. A pooled trust I talked about a little bit briefly before. They are for people who have disabilities. So you have to prove that you have a disability to have a pooled trust. However, this only has to reach the standard. And if you've ever read the SSI standard, it is very broad. It basically says you have something that makes you unable to work, or something that's going to lead to your death eventually to qualify for disability. So if we can prove that she can set up disability, her power of attorney would be able to set up a pooled trust. Once it's in a pooled trust, it's kind of like having her own bank account. Everything in the pooled trust can only be spent on Clara. She can't, buy gifts for anybody or pay for anything that Medicaid or other government benefits would pay for. But if she needs something down the way, let's say 3 months after she's on Medicaid, she needs a new TV, you could use the pooled trust funds to buy it for her, because otherwise she's only going to be able to have $2,000 plus $50 from her income, because the rest of her income would go to pay the nursing home. So she would only get to keep $50 a month, which is not very much for most people. So the pooled trust can really add a quality of life to Clara's life. The reason that we might prefer this plan to the first plan is we don't think that we have beneficiaries that we're looking to leave money for. Some parents, it's really important that they try to leave money to their kids. But in this case, Clara doesn't have any children. And mostly we're going to look at how we can make this money last the longest for her. So then in example number 2, we've got Bill, and Bill is married to Betty, and they have no kids. So health-wise, the problem is Bill has developed Parkinson's and Betty can no longer keep him at home. So he's looking at going into a nursing home full-time. So we're going to look at both of their income. Bill is making $1,975. He's got the Social Security, he's got the pension, and he's got a required mandatory distribution that comes monthly. And then we look at Betty's income. Betty's doing a little better financially than Bill. And so Social Security wise, pension, a VA payment, a required mandatory distribution, and a distribution from her 401k has her up to $4,000 a month that she's making. Asset wise, they've got a good chunk of assets. They've got the home. The home is paid for in full and it's worth $150,000. They have a van that's specially designed to fit Bill's wheelchair. So that's $40,000 van. Betty has an IRA that's got $150,000 in it. She's also got a 401k that's $50,000, and Bill's IRA is $75,000. Then they have a couple joint accounts. They've got a joint checking account with $25,000 in it, a joint savings account with $25,000, a brokerage account with $100,000, and Betty's whole life insurance, which has a cash value of $25,000, and Bill has term life insurance, which is $100,000. Other factors, Betty has a power of attorney for Bill that allows for gifting. So she can make transfers of his assets into other people's names. So what are we going to do for Bill? No qualified income trust is needed. Bill's money is low enough, his income every month, that he's not going to need a qualified income trust. Betty's income is very high, but she is the community spouse. So we're not looking at her income, only Bill's. The total snapshot at the date that they are looking to apply would be $175,000 because when they are looking at it, remember, we're not counting the retirement accounts right now. Those are not countable assets according to the Ohio Department of Medicaid. So on the snapshot date, even though they've got all of those assets, they're really only looking at a couple of them, that the brokerage account and the bank accounts and the life insurance policy. So Betty gets to keep the house, she gets to keep the car, and she gets to keep her retirement funds. Plus she gets to keep half of the $175,000. She gets to keep $87,500. Bill gets to keep $2,000 or less and his retirement accounts, because under this, we're going with the Ohio Department of Medicaid's ruling right now. So then we have to spend down the rest. We have to spend down the excess so that Bill can qualify for Medicaid. And it's important that you get the snapshot date established first, because otherwise you're spending down the whole in total. Once you get the snapshot date established, you can only you're going to spend down the half. But until that point, you're just reducing all of the assets. So you get to keep about almost 50 cents on the dollar to every, every extra dollar you apply to the snapshot. So how are we going to spend the money? First thing we're going to do is prepay funerals. Everybody's going to need them. They're very expensive, and it saves a lot of stress on the family later on when it comes time for them. So we'll prepay funerals for both spouses, $20,000 total. We're going to pay the attorney fees, $15,000, and then we're going to invest in improvements on the exempt assets. So we're going to pay debts and purchase anything needed. So we'll pay off any credit card debt they may have. If they have a mortgage, we will pay that off. If they need a new kitchen, if they need a new hot water heater, if they want to sell the van and get a better van, they can do all of those things with the money. It's just about investing it for the two of them. As long as they're not making gifts during this period, Medicaid's not really looking too much at otherwise. So what would we do if we cashed in Bill's IRA before the snapshot date? Because remember, Bill's IRA is exempt, under the new rules, but if we cash it in before we get the snapshot date, we can make the snapshot date a little bigger. So still no qualified income trust needed. Bill is below the income requirement. So if we cash in his IRA and we withhold for taxes, which is about 25%, we can add $56,000 to the snapshot date. So this bumps us up and it makes the total snapshot $231,250. So in this case, Betty still gets to keep the house, the car, and her retirement funds. Plus, she gets to keep extra money that she wouldn't have necessarily gotten to keep before. That money still would have been in Bill's IRA and it would have been protected, but that income that came out would have gone to pay for his nursing home care before. And so now she gets to keep this extra amount. Bill now gets to keep $2,000 alone. And then we need to spend down the excess to qualify for Medicaid. And so we're doing all the same things, but now we have extra money to put into the house, to put into the cars, to pay for whatever would make their life better, especially if it's something that's going to happen in the future. For example, if we don't want to get them on Medicaid and then have the roof fall in after that. If the roof is looking old and we know it's going to need to be fixed up in the next 3 years, that's the point when you're spending down money to fix the roof. That's the point to do the hot water heater and to do all those things that's going to let Betty keep as much as she can living in the community afterwards. Do I have any questions yet? I have more hypotheticals, but I don't know. I get tired of hearing myself speak sometimes if anybody has questions.
I have a question.
Yeah.
Once you have signed up for Medicare, are you on it for the rest of your life, no matter what? I mean, can you say, I don't want to do this anymore? I mean, if someone wants to do that.
Medicare or Medicaid?
Medicare.
Medicare. You can change your plan. I mean, once you're on Medicare, you can, like, if you're Part A and Part B, you can switch to Part C. But yeah, at a certain, you can come in and change your plan later on as you go.
But are you penalized if you just say, I don't want Medicare anymore, period? I actually know someone that said that. Can they do that?
They are required to have comparable coverage through something else.
Okay.
At this point, just not having medical insurance is not really an option in this day and age.
Okay.
But they can switch to, Medicare C or some other form, but they need to have some form of coverage.
You only do that during from now till December 7th? Is it?
That's for the initial enrollment. Afterwards, I believe that it's the enrollment period for Medicare C is based off of a date. Let me see. I thought I maybe had that there. Yeah, there's a different date at that point that you can enroll. But yes, there is a period of time. The same way with like your current, with your current insurance where you can only switch at a certain point. Yeah.
Okay. Thanks.
Yeah. But yeah, just throwing your hands up in the air and saying, I don't want that anymore. I don't know.
I know you probably never heard that one, right?
I've had clients who I've talked through all of this, like the wills and the power of attorney and all of that. And probate and how transfer on death affidavits work and things like that. And I've had a couple of people who have just thrown their hands up in the air and been like, that's too complicated. I'm just not going to die.
Oh, there you go.
Yeah. It's like, all right, that's a great plan,
Yeah.
but
I didn't know that was an option.
yeah, like plan B, maybe work a little better just in case. But yeah, it is all very complicated, but Medicare, at the end of the day, it is an insurance policy similar to, the other insurance policies that people under 65 have. I know, like just this morning, I had a problem. I was supposed to, I'm going to the dentist. I've been on the phone for like 4 hours with like, trying to figure out, you know, if my dental covers it or if my medical insurance covers it, etc. I'm getting wisdom teeth at 35 apparently, which is ridiculous. But just trying to figure out which branch of the insurance and if the doctor's in network or not in network has been quite complicated overall. And, you know, the woman who was calling me at the doctor's office was like, yeah, I've been doing this for 30 years and it's so complicated. And the insurance game really is right now. But Medicare and Medicaid, once you get the broad basic strokes, you know, everything does work within certain rules. But yeah, for Medicaid, once you're over 65, I've known there's a couple people who go on it and then come off it, but it's not, when you really need the long-term care, a lot of times it's harder to come off of Medicaid because you've spent down to the $2,000 at that point, and how are you going to afford different things, you know? So the Medicaid is, I think, a little harder to come off of than transferring through Medicare to like Medicare Part C, a C plan.
I have a question from Perul. She wants to know how expensive the legal fees are for all this planning and at what age do you recommend people do this planning?
It 100% depends on the situation for the legal fees. I bill about $250 an hour. So depending on how much planning, you know, I have some people who just come in for like a 1-hour consultation. We go through all of their assets. We set up the wills and the powers of attorney. There's a charge for that. My office charges about $750 for the entire packet. And that includes the $250 fee that I was talking about before. But that gets you powers of attorney for finance, healthcare, living will, a review of all of your assets and how to set it up in probate, outside of probate, whether you have gifting powers, what your plan is overall. So that costs about that there. For a more advanced like Medicaid planning, transfer, gifting, trust setup, annuity gifting plan, I would charge far more. Usually I charge the cost of either 1 month in a nursing home or 2 if we're doing an insanely complicated plan. But if you're paying that much in legal fees, for a gifting plan like that, I can usually save about half of the assets. So it's not uncommon that you may be paying me like $6,000 to do it, but I am saving you $85,000 overall that would otherwise be spent down for a nursing home payment. As to when to come see me, there's a couple different times that I suggest people go see an attorney. First of all, as soon as you turn 18, I know that that sounds too early because you don't really have assets. At that point, you're mostly worried about when your kid turns 18. If they are in a car accident, the doctors at the office will not talk to you as their parent if they are over 18. If they are stranded in Italy, you know, and they need they need money taken out of their bank account and wired over to them, you can't get into their bank account unless you have a power of attorney for finance. So really getting those powers of attorney set up pretty much as soon as you turn 18 and then keeping them maintained through your lifetime, I think is really important. I just updated my power of attorney the other day. I've had one since I was 18 that allowed my parents to make medical decisions or whatnot. I recently got engaged, so I switched some of my powers of attorney. If I'm in the hospital now, he's going to be the one next to me holding my hand, so I want him making those decisions. So it's, even if you get it done, you're going to need to update it because your life changes as things go. For assets, like, you're always going to want to have an idea of where your assets are going as you acquire more. So, you know, is your house passing through probate, or is everything going to be able to go to your spouse immediately without, you know, going through probate, paying fees, jumping through hoops and all of that. So getting your estate plan set up, the main points that people come see me is child turns 18, especially if they're a disabled child and we need a guardianship for that child at that point. Once you get married, or when you have assets, when you have your first kid, who's going to be the guardian of that child if both you and your spouse were to pass away? What money do you want to go to that child? Do you have life insurance policies? What's your plan there? And then as you get older, for this Medicaid planning that I'm talking about, I usually see people at a couple times. I see kids when their parents have gone through it, because they see their parents going through this entire thing and they're like, that won't happen to us. We want to be prepared. I see people when they first get that diagnosis of Alzheimer's or Parkinson's or, ALS, not so much the cancer and the heart problems, because with those, you either get better or they take you pretty quick. So with those, I may see people for estate planning, like, oh my God, we waited up until this point to do a will and we don't have a will, so I need a will. But for the ALS, those long-term diseases, it is best to get in immediately as soon as you get that diagnosis, to go see somebody to see where your assets are and what your thoughts are on things. Because some people, you may have a different idea of like, do you want to be able to transfer assets to your kids to try to protect the assets, or do you want them to pay for that private suite and every last penny to go to your care? And at what point, I have kids and parents who are promising their kids like, no, you never put me in a nursing home, no matter what. And, I'm going to come live with you. And the kids may not know that that is the plan. And they may have thoughts on what the plan is for if mom were to come live with them. So it's really good at that point. I also see people, the most times I get referred people, sadly, is they are looking at going into a nursing home immediately, or mom's already in the nursing home and they're looking at the bills and going, oh my God, this is $8,000 to $10,000 a month. How do we pay for this? And those ones, I can help. I can help with the spend down. I can help apply for Medicaid. I can help with all of that. But I can't do quite as much as I could have at the beginning. And I especially can't if I don't have a power of attorney in place, or I don't have a power of attorney with the appropriate gifting powers. That'll keep me from doing a lot if I don't have the ability to transfer things around and move things. Or if you've been in the nursing home for 10 months and you've paid, $100,000 out, there's far less options you have, the less money you have for how to transfer and how to pay for things. So a lot of times I will see people at that point. Right now with the COVID, we're seeing, we're running into a lot more issues just because of accessibility. It used to be that I would do a lot of home visits. I would go to the nursing home. I would go to the hospital and be, at the bedside helping somebody, figure out their estate plan. I can't get into the hospitals now. They don't let anybody in. And I have trouble getting to the nursing home. And there are some requirements for, witnesses and notaries that are very hard to get around. And especially if you had somebody who loses. So if you have a stroke or something along those lines, you can't communicate what you want. That can be a really big issue with clients is, they can't tell you. And at that point, you're really looking at a guardianship action, and God, I hate guardianship actions. They're long and they're complicated and they're very expensive, and they can bring a lot of fighting in the family, especially if you've got something like dementia where mom doesn't know she has dementia, or she's flat in denial and she's like, no, I can make my own decisions. And daughter's like, she's not making good decisions. And then daughter has to sue mom. And then there becomes a question of having to declare, that they are incapacitated and incompetent. And to have that legally declared as a public record is very embarrassing. And to have it in a fight. And then of course, there's always the problem, like, if I were to bring that against my mother and I was wrong, like the judge sided like, no, she's making bad decisions, but she has the ability to make bad decisions. At that point, I've really ticked off my mother because I've sued her for control at that point. I don't know if she's watching today. My mother may be watching today. And if so, I'm sure she would agree that I am not to sue her for guardianship. Other questions or about other aspects of what I do, or?
I just have a quick comment. I think you're saying that you did yours at 18. I've recommended that for my own adult children. It would be a wonderful 18th birthday present as a parent. It's the gift that gives you both, because that would be something. So I don't know how we can market that, but I think you need to do that. Just
I think it's going to be a hard sell for the 18-year-old, especially if the 18, like my baby brother, he, I say baby, he's 30 years old now. Like when he turned 18, he was, you know, he didn't want his mom to be his medical power of attorney. He was like, nope, my sister can make those decisions, and I don't want any information to be released. I think he was, I don't know, dabbling with marijuana or something at that age, you know, that's legal now, but didn't want mom to know. So
yeah, still able, but still designated you. It's like whoever they want, I just think it's a really good idea. 18-year-olds are not going to think of it on their own. And for parents, it's a great idea.
And you may not have assets at 18. Like at 18, I had like a car, which it can be good to make that transfer on death in case you do pass away, which 18-year-olds are not thinking about. But, you know, as you get more assets, there's more of a need to set up a will and a estate plan and a transfer on death affidavit and all of that. Because, you know, if you've got nothing but debt and a small bank account, you know, you'd still like to know how that bank account's going to go. But, you know, the more assets you acquire, and the more unconventional your family unit is, because you know, if you're married, I still think you need a power of attorney and, you know, an estate plan, because you can avoid a lot of headache of going through probate if you're married. But even if you're married, if you pass away without a will, the way the law is set up, that is that first it'll go to your spouse, if you don't say otherwise. And if it doesn't go, if your spouse goes with you, then it'll go to your kids if you don't have a spouse. And if you don't have a spouse and you don't have kids, then it goes up. So then it goes back up to your parents. So if you pass away, you don't have a spouse, you don't have children, it'll go to your parents. If your parents are not alive, then it goes to your siblings, and then down the line there. And then it goes back up again to go to your, you know, aunts and uncles, and then down the line. And eventually you get to a point where we have what's called a laughing heir. And that's an actual term. And it means somebody who is inheriting who didn't know you well enough to be sad at your funeral. But yeah, so if you don't have an estate plan set up, especially if you are single and you don't want it to go to your parents, you may want to think about setting it up for, you know, to go to a charity or to go to friends or anything like that. Because, you know, if you passed away, where would it go?
We had one quick comment. It was not a question, but it's a student who says she has learned so much. The little amount of assets they allow in order to qualify and the penalties they impose if people go over a cent was astounding to me. Medicaid's idea of poor can be very different from ours.
Yes.
Yeah.
Yes, definitely. Yeah.
And she said, setting up and maintaining the power of attorney were news to me as well. Thank you for all the information, Kyla. And she said she has to go to class now. So that's why she had to get off. So I'm just letting you know that, you know, a student was very appreciative. And I think we are about, I want to thank you very much. I think I learned a lot. And I'm sure others did as well. I appreciate it very much. We all do. And I just have a quick note for all of those that are on the geriatric resource certificate. If you have any questions about the process, about viewing the past presentations or getting on the LMS, please reach out to us. I think you have all of our contact, either Denise Kropp, myself, or Sue Hazlett, or Michelle Guerreri. So yes, and we will see you again all soon. Thank you again.